What am I doing? Oh my God, I don't know how to do things anymore. I need help. This is all Colin's fault, y'all. I was watching Colin's stream. I forgot I was even streaming tonight. It's Colin's fault, not mine. Yes. Dreams is the one who sent me a message and said, hey, tap, tap, tap. You know? All right, voted up, chat. Do we listen to music for a couple of minutes? Or do we get started now? I'm muted and you can't hear a word I'm saying. That's how these things work. By my reckoning, I'll start all over. By my reckoning, the guitar was whining. So somebody in Texas has the blues, and it's that fellow's fault right over there. I don't know, though. I've got 2 hours of Fleischer ahead, so let's all watch some of it, shall we? Let me get it queued up over here, because I don't know how to. I don't know what streaming is. I don't even know what I'm doing right now. I'm just existing. Ladies and gentlemen, welcome to the Fleischer Forum. Let's get right into it, shall we? Start.
All right, let's roll, nerds. Right, ma'am? Hi.
Page 24, Sagara, come on up.
You were Daniel Sagara?
Yes, Your Honor.
To Sagara, you're charged with 2 cases. You're charged with assault, bodily injury. You're also charged with terroristic threat. You're facing up to a year in jail on the assault case. You're facing up to 6 months in jail and or a $2,000 fine on the terroristic threat. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge. Officers were dispatched to a bar in Harris County, Texas in response to a disturbance. The first complainant, the bartender, told the officers that he refused to serve the defendant alcohol because he appeared to be intoxicated. The defendant became angry and began yelling at the first complainant and other patrons. The second complainant, the bouncer, then approached the defendant and told him to leave. The second complainant reported that the defendant was continuously reaching for his hip and motioning as if he had a firearm. The defendant then stated, "Y'all are gonna get these hollow points. Touch me and y'all are gonna get it. I'm gonna fire this motherfucker out." The second complainant once again told the defendant to leave, and the defendant pushed the second complainant on his chest, causing pain.
You look to see if he's on probation or parole by chance.
It doesn't appear he's on probation, Your Honor.
Mrs. Segarra, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using alcohol or drugs, I'm going to put you in jail. I will deem you a public danger, and I'm going to make your bond sky high. Do you understand?
Yes, Your Honor, I understand.
No alcohol, no dope, no illegal drugs, no going back to this location, and no weapons. Do you understand?
Yes, Your Honor, I do.
Mrs. Segarra, I want you to understand that I'm going to do everything in my power to protect the public, and I don't care if I have to put you in jail kicking and screaming. Everything in my power to protect the public at all costs. Do you understand?
Yes, Your Honor, I do.
Don't make any false moves. Don't go to any bars. Don't go to any establishments where the primary purpose is consuming alcohol. There are some people in life, when they consume alcohol, they become happy, giddy, like little bunnies jumping in the woods. And then there's some that turn into Jekyll and Hyde and develop horns. I don't know what kind you are, but if that happens, no alcohol. Do you understand?
Yes, Your Honor, I do.
You have a lawyer. It's your responsibility to stay in touch with the lawyer. She will tell you if and when you have to come back to court. If she tells you that she can't get a hold of you because you're playing games, likewise, I will issue a warrant for your arrest. You will not get any more PR bonds. You understand?
Yes, Your Honor, I do.
Have you signed the reset with Victoria? After that, you'll get pre-trial for your bond conditions, and then we'll have you take a seat, sir.
Right this way. Go ahead and sign for your reset. All right, Judge, the next arraignment, Spanish speaker is page 16. Martinez, come on up.
Oh, well, since the Colin people are showing up, I guess I should, do the perfunctory Colin Paws and say, welcome, Colin Raiders. Thank you very much for coming over. I want to say hello. We're only into the second case of the Fleischer Forum right now. The first guy looked a lot like Colin. Just saying. That's all I'm saying. This is the one and only Paws for the Colin Raid, ladies and gentlemen. Let's get back to it, shall we?
Martinez Velasquez.
Christian Martinez Velasquez.
Sí. Yes.
Mr. Martinez Velasquez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and/or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On November 7th, 2024, the officer alerted dispatch about a traffic hazard regarding the defendant's motor vehicle after observing it sway in a moving lane of traffic, impede traffic when the defendant had the green light, and upon contact with the vehicle, the officer observed the defendant to be asleep in the driver's seat. The defendant's foot was on the brake and the vehicle was on. After the officer woke the defendant by banging on the window, he seemed disoriented, and the officer observed glossy, bloodshot eyes, an odor of an alcoholic beverage, and slow movements. The officer observed an open Modelo beer can in the cup holder next to the vehicle.
Alcohol in the car while driving?
Yes, Your Honor. And the defendant admitted to drinking 3 beers and 1 shot before driving. Standard field sobriety tests were administered. HGN 6 out of 6, walk and turn 4 out of 8, 1 leg stand 0 out of 4. The DIC was read and the defendant consented to breath. The results were 0.087 and 0.086.
Mr. Martinez Velasquez, I'm going to find that there's probable cause to go forward with the case. Are you a citizen of the United States?
No,
Are you in this country with or without permission?
without permission.
What happens if you go to jail?
Ya, sé que tuve un error y
I don't know.
What happens if you go to jail?
Si usted va a la cárcel.
Are you in this country with or without permission?
Es como sin permiso.
sin permiso. y-
Without permission.
What happens if you go to jail?
O sea, si usted va a la cárcel.
No sé qué decir, pues tengo mi familia, tengo mi hija.
I don't know what to say. I have my family, I have my daughter.
I don't care if you have Jesus waiting for you.
Si tiene-
You're not answering my question. What happens if you go to jail?
pasa si usted va a la cárcel?
I want you to
¿Qué le
think.
pasa? Quiero que piense.
Pues que voy a estar, no voy a estar libre, voy a estar en un lugar donde no quiero estar por mis consecuencias.
I wouldn't be free. I would be somewhere I wouldn't want to be because, as a consequence,
You are not in this country with permission.
no está en el país.
If you go to jail,
Si usted va a la cárcel,
immigration sweeps the jail every
cárcel,
couple hours. If they find you in the jail,
eh,
they will put an immigration detainer on you and you will be stuck like Chuck in jail until this case is over with. And then you get shipped off to immigration where you will sit for another 6 to 9 months waiting for them to do whatever they're going to do. The incoming president does not have very much sympathy for you, if you catch my drift. And I'm going to tell you now, the fact that you have an open container, if they allege it in the information, it is a minimum of 5 days in jail to any sentence that you do. Now, I'll tell you, any more than 4 to 6 hours you spend in custody is very well that you may get an immigration detainer. I am putting conditions on your bond now, and if you violate these conditions, I will, in a moment's notice, put you in jail, and I will not give you another PR bond.
no le daré otra
The
vez.
reason you got out of jail so quick is we gave you a free bond.
De la cárcel.
It's not going to happen again. Do you understand?
¿Entiende?
First and foremost, you are not to drive. I don't care what's going on in your life. I don't care what you need. I don't care what you have to do. Kids, groceries, Jesus, don't drive. You will be signing an affidavit. This is a promise you're making to me that you're not going to drive. I am also ordering you not to consume alcohol or illegal drugs, and I will randomly test you. If I find that you're consuming alcohol or illegal drugs, likewise, you will go to jail. You will not get any more PR bonds. Do you understand?
Correcto, sí.
Yes.
Forewarned is fair
Te he
warned.
advertido.
You will not get any warnings from us.
Okay.
We are going to reset your case to give you time to hire a lawyer. So I will have you come up here, swear to us that you're not going to drive. I'll get you to Victoria where we will have you sign a reset. And after that, we'll send you out here. And when you come back, have a lawyer, sir. Do
Cuando regrese, dice,
not drive.
Okay.
Okay?
All right, Judge, next is page 5, bio. Come on up.
Good morning, Mr. Bayo.
Morning.
Mr. Bayo, you're charged with assault of a family member.
Yes.
You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Okay.
Officers were dispatched to an apartment in Harris County, Texas, in response to a family disturbance. The complainant told the officers that he lives in the apartment with his ex-wife and her current boyfriend, the defendant. The complainant and ex-wife began arguing about money when the defendant became involved and punched the complainant with a closed fist 2 to 3 times, causing pain. The officer observed bruising on the complainant's face and a cut on his lip. The defendant told the officers that the complainant threatened to hit him first, but admitted to punching the complainant.
Look how you always come up here, Lauren.
I'm sorry,
You always come up here on these cases.
just in case you have any questions, but
So what is the relation?
The relationship is,
so I believe that the defendant is dating the complainant's ex-wife. So the defendant and the complainant are not related, but it's just the ex-wife. I believe.
Do we know if she wants to have, contact with him? Do you know anything?
So from what I understand, because our back tried to reach out, they all share a phone.
3 people sharing one phone.
That is what, according to our back. So I called and I was able to get a hold of the ex-wife who gave me the number, another number for like the complainant's business, I think his business phone maybe. I tried to call, they just left a voicemail, I wasn't able to get in touch with him. So I'm not really sure entirely about like contact between all of them, but I know they're all living together.
Okay.
Yeah.
So I'm going to order, until I know that she wants to have contact, I'm ordering you not to have contact with this person. Mr. Bayo, I'm going to find that there's probable cause to go forward with the case. Any alcohol or dope is an allegation in this?
no, Your Honor, there's no allegation of alcohol.
Okay. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of weapons. I like to follow the wishes of the complaining witnesses, and I don't know if she wants to have contact with you or not. So until I know, don't have contact with her. There is a protective order in place. You need to get to know it, because if you violate the protective order, the state can and will file additional charges against you and things will go sideways real quick. Do you understand?
If I may, the complaining witness is a man. It's his he's currently dating the complainant's ex-wife. So
Yes.
it's a male.
Yes, so the
complainant.
female is not the
Yes.
complainant in this case.
Okay, it's the male.
Yes.
Got it. Regardless, I don't want contact. I don't care what gender, sex, color, creed, doesn't mean, nothing matters. My only concern is public safety. That's all I care about. You endanger any person, place, thing, whatever. There's only one place that we have for you. Do you understand?
Understood.
How old are you, sir?
28.
What do you do for a living?
Right. Oh, she flew me out here from Maui. I was working over there at an electrical supply company. I did UPS stock transfers at the end of the day.
So you have an income.
I did have an income. Currently, I'm not working.
Why?
I'm waiting for my ID to get shipped here, my hard copy. My paper ID just expired this month on the 11th.
So did you stop working? How have you been working? You stopped recently?
I stopped in Maui, unemployed here when I arrived. I came here to help her with her 2 daughters, fraternal twins who are just making 2 this month as well. She's having troubles with her ex-husband. He has a past mental history, health history with schizophrenia. She says he
I don't want to talk about the
Yes,
case.
yes, yes.
My only concern is that whether you can afford a lawyer or not.
no, I cannot afford a lawyer.
Okay, I want you to understand that there are a bunch of restrictions on here. One of the restriction is a residential restriction. You're not allowed to go back to this house for the time being. I will appoint your lawyer now so that we can get more of your side to see how we go forward. But don't pick up any new cases. Don't violate these conditions. You got to understand, you got out because we gave you a free bond. You violate conditions, I'm going to put you in there. You'll have a $5,000 to $10,000 bond. And if you don't have anyone to put up that kind of money, you will be stuck in there for the next, could be 9 months. It takes 9 months just to get a 911 tape. So when you're out in the free world, think before you act, think before you speak. Because if you do it wrong, you may be with us for a long time. You understand?
Understood.
I need you to fill out an application for an appointed lawyer. Stephen is going to give an application. We'll have you sign a reset with Victoria, and then we'll have you take a seat in the jury box. Do not leave until you sign all our bond conditions. Otherwise, I'll issue a warrant. Do you understand, Mr. Bayo?
Yes.
Okay.
All right, Judge, next is page 10, free. Come on up.
So you found no contact, no weapons, please.
Yes.
Thanks. Danielle Free. Miss Free, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge.
Okay.
On November 6, 2024, officers conducted a traffic stop on the defendant's motor vehicle after observing it speeding 55 miles per hour in a 40-mile-per-hour zone in the 7800 block of Spencer Highway. Upon contact with the defendant, the officer detected an odor of an alcoholic beverage on the defendant's breath, and standard field sobriety tests were conducted. HGN 6 out of 6, walk and turn 3 out of 8, and one leg stand 3 out of 4. The defendant admitted to drinking and to taking prescription muscle relaxers on occasion. The officer located a case of twisted teas in the defendant's motor vehicle with 2 open cans of twisted teas, 1 in each cup holder. And
So consuming while driving?
there were 2 open cans in the cup holders, yes, Your Honor. And DICs were read and the defendant consented to blood.
Ms. Free, I'm going to find that there's probable cause to go forward with your case. I'm now ordering you not to drive. Do you understand? You are not allowed to drive any vehicle whatsoever for any reason. You will be signing an affidavit with me today, promising me you're not going to drive. If I find that you do, I will have a contempt hearing. You'll be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? I'm also ordering you not to consume alcohol or illegal drugs. You will be randomly tested. If you consume alcohol, illegal drugs, unprescribed controlled medication, likewise, you will go to jail. No more PR bonds. Do you understand? Any prior DWIs, Alex?
No, Your Honor.
Any prior criminal history at all?
She has a prior racing on a highway that was dismissed earlier this year.
What do you do for a living, Ms. Free? Why?
I just graduated nursing school, so I was a CNA and caregiver for in an independent care facility. But right now I help take care of my great grandma, so it's just a lot at once.
So how do you support yourself? How do you eat?
I live with my grandparents and I help them take care of her. She can't take care of herself. She has dementia and a mental disorder.
I'll fill out an application for you. I need to know everything about you, how much money you make, what kind of car you drive, any source of income that you have, money in the bank, stocks, bonds, IRAs. I'll have you fill out an application, but I need to know everything about you. Don't just put zeros because I'm going to send it right back to you. Do you understand? And I'll see whether you qualify. Above all else, do not drive. Do you understand? There's no justification that you can give for getting in a car. Likewise, don't consume alcohol or drugs. If you have a problem, you better address it, because if you don't, I'm going to do it for you. Promise you're not going to like the way that I do it. You understand? Okay. Do you mind giving me an application, please?
Page 11.
Good morning, Ms. Furlow. Ma'am, you're charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. Officers were dispatched to a residence in Harris County, Texas, in response to a disturbance. The complainant stated they were in their car and backing out of their driveway when the defendant parked behind them. The defendant then got out of her car and started banging on the complainant's vehicle while shouting obscenities and threats. The defendant also tried to gain entry into the complainant's vehicle. Specifically, the defendant stated she was going to whoop their ass, and the complainant stated they were in fear for their lives during the incident. The officers discovered the defendant is a coworker of one of the complainant's family members.
Owner, boss.
So the threat is what?
The threat is she was banging on the door and said, "I'll whoop your ass."
I have it on camera.
And I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have any contact with this person and not to be in possession of weapons, okay?
Hired.
What do you do for a living, ma'am?
I own a fleet company, 3 trucks, and they're my drivers for the road, my OTR drivers.
Okay,
So they just basically stole my vehicles.
we are going to reset your case to give you time to hire a lawyer. So I'm going to have you go to Victoria, sign and reset. We'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then you'll be free to go. When you come back, please have a lawyer, okay?
Okay, but I move out of state next month, so I just talked to them about.
We'll have you sign a reset, and then we'll just take a seat while we get your bond conditions. We'll have you sign the bond conditions, and then you'll be free to go. Okay, please. If you can file no contact, no weapons.
Next judge is Garcia. Gregory, page 11.
Are you Gregory Garcia?
Yes, Your Honor.
Mr. Garcia, you're charged with failure to comply with the duty, basically leaving the scene of an accident without exchanging information. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
In June 27, 2024, officers were dispatched to a residence regarding an accident FSGI call. Upon arrival, the officers met with the complainant and the witness. The witness stated he was on the balcony when he observed a dark-colored Dodge truck sideswipe the complainant's vehicle that was parked on the side of the road. The witness advised he informed the complainant of the accident, and upon going outside to inspect the vehicle, the striking vehicle and at-fault driver was still on scene. The complainant observed the defendant to be intoxicated due to slurred speech, and the complainant stated the defendant then fled the scene in his vehicle without providing his information. The complainant's vehicle sustained major damage, and the complainant advised it will cost at least $5,000 to repair.
He saw him sideswipe though, right?
Yes, the witness saw him sideswipe, yes.
Got it. Okay, Mr. Garcia, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If I find that you're consuming alcohol or illegal drugs, I will put you in jail. You will not get any more PR bonds. Do you understand?
Yes, Your Honor.
You have a Texas driver license.
Yes, Your Honor.
Do you have valid liability insurance in your name?
Yes, Your Honor.
Are you sure?
Yes,
You
Your
have car insurance.
Yes, Your Honor.
Can you run his license, please? In addition to not consuming alcohol or drugs, I'm also going to order you not to have contact with the complaining witness in this case. If you understand. Okay.
Your Honor, he's eligible.
All right. So what we're going to do is I see that you have a lawyer,
Yes, Your Honor.
correct? They're not here yet. So I guess what we're going to do is we're just going to have you take a seat, wait for your lawyer to get here. So that way we can get a good date for you guys. And then I'll have you leave with him or her. Okay? Please.
Right this way. Judge, were those state's conditions?
No, you.
Random testing.
Yeah, no alcohol, no drug.
What was the last name again?
Garcia, bottom of page 11.
Page 12.
Can you bring him up?
Sir. Mr. Revocation, come forward. Right there.
You don't have the heater on, do you?
No. It's one of the blankets.
Please, no heater. Thank you so much for coming.
Yes, sir.
What is the gentleman's name?
No person you should read.
Oh, is it Gideon?
Yeah.
Are you Mr. Gideon? Shh. Mr. Gideon?
Yes.
Good morning, sir. Mr. Gideon, you are charged with assault of a family member. Do you understand the charge against you? You are facing a year in jail and or a $4,000 fine. We need to do probable cause. I need to find out what happened. So we're going to do that real quick. You have the right to remain silent. Anything you say can or will be used against you. Is he okay to understand everything? Yeah? Okay. All right. So we're gonna do that real quick. We'll find out what happened, okay?
Yes, Judge.
Okay, go slow, Alex, please. No. Stay here, stay here, stay here. We need to just find out what happened.
Yes, Judge. The complainant and the defendant are mother and son. The officers were dispatched to apartments in Harris County, Texas, in response to a family disturbance. The complainant told the officers that the defendant is diagnosed with mental disabilities and that he is known to wander away from the residence. The defendant was upset because he was not being allowed to leave and grabbed the complainant on the forearm, squeezing it with full strength and causing scratches, bleeding, and pain.
Is mom here?
She was, he asked her to leave.
I just asked her to step out. She wasn't properly dressed for court, so.
Yes.
Can you bring her in,
Over here.
please?
That's if she, I went out there a few minutes ago, I didn't see her.
It's okay. Hopefully we can find her. Mind just hanging out with us? I'd like to wait until mom comes, so we left all the way. Do you want to call her? Do you want to call to see if she's, you can use it here. That's fine. Just call her.
She's not even out from the phone.
41.
I'm sorry, she's not even out from the phone.
Do you think she'll come back? I mean, we can wait. There's no rush. If you want to just like,
Probably step outside. I need to
sure,
get off
take
the
your
phone.
time, but just don't leave though, because I want to give you guys a lawyer and I want to talk about how to go forward. And I'd like to talk to
Right here, and I'm going to go out and look for
right over there, just wherever you want, but don't leave, guys,
her.
okay?
Hang on,
Okay,
I'm right here.
yeah, take your time, no rush.
All right, Judge, the next one. Seventeen. Oscar Martinez, come on up. Counsel, you have the
Do you speak English?
Yeah.
Come on. You are Oscar Martinez. Mr. Martinez, you're charged with failure to stop and give information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. Officers were dispatched to a residence in Harris County, Texas, where the complainant told the officers that the night before, his mom heard a crash outside their house, but did not go outside. The following day, the complainant went outside and saw that his vehicle, which was parked on the street, had been hit. The complainant followed the tire marks and debris to a house approximately 400 feet away, where he observed the defendant's vehicle with visible damage. The officers arrived and observed blue paint transfer from the complainant's vehicle to the defendant's. The officers spoke to the defendant, who said he had no recollection of striking the complainant's vehicle, but admitted to have drinking approximately 6 beers the night before.
Great. You've got A, you've got C, but you don't have B. How do we know it was him?
Your Honor, the connection would be the blue paint.
I understand. How do you put him driving the car? How do we know it wasn't Meemaw,
Your Honor, let me check the,
Peepaw?
I'll check the OR, see if there's any further information.
Martinez.
Sagara.
It's an FSGI. Don't say anything. Are you losing?
Sorry, what was it? Yes, yes. So Judge, the defendant admitted to driving at the time that the car was being struck. He admitted that he was driving home from a party at that time. He said,
Alex didn't say that.
That was in the.
right, it's in the OR, Judge, it's not in the evidence, but that's what the.
Didn't
officer
give me,
was-
said, does he admit to the accident?
He does not. He says that he was driving, he does admit to driving home at the time that the car was struck, but he says he doesn't know about anybody being struck, but he just admits to drinking at the time of the accident.
We don't work on hunches, man. We don't. I need more than just a hunch.
It's not a hunch, argument's not it's not a hunch. He's admitting to driving at the time.
He admits to driving at the time, but doesn't admit to the accident, doesn't admit to anything like that. All he says is, I'm driving at the time.
Well, Judge, based off of the nature of the accident, the extremity of the accident, the pain transfer of the car, the state's position is that there'd be no way that this defendant could not have known that there was an accident at the time.
I don't know. I'm sorry. I'm gonna find no probable cause. I mean, if you get something else later, let me know, but at this point, be careful, Mr. Martinez. You know what I mean? You've got one life. You're drinking, driving. We lead the nation in DWI fatalities. Lead the nation.
Yes, sir.
Where's my phone? $10 on a click. $20 will get you anywhere you want to go in this city. You know what I mean? Use it. All right. I'm finding no probable cause. Just take a seat for me momentarily, sir.
All right, Judge, the next one is page 18. McGaskey. This one was a refile, Judge.
Okay. Was this one indicted or
I believe so. Michael, do you know?
was this one indicted? Okay. So probable cause has already been found then.
Yes, Judge, stand that, yes.
Michael, did you file the dismissal on the other?
It should be dismissed already, yes.
Did you file that on the-
I see. I don't see a dismissal on that one. I don't see a dismissal on it.
I can follow that right now.
Sure. Okay, so let's see. Okay, so Mr. McGaskey, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. So you know how it works, right? I found no probable cause in your case, but they went to a grand jury and the grand jury indicted it. That means that other people found it sufficient to find probable cause. So now we have to go through the whole show again. Do you have Mr. Henderson here helping you?
It's in another courtroom. He'll be here when he gets done.
Do you know he'll definitely be here?
Yes, sir.
Yeah, okay, good. So all I'm doing is I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. I will randomly test you. If you test positive for drugs or alcohol, your bond will be revoked. You will go to jail. So just don't drink, don't use illegal drugs. You'll be fine with us. Do you have a Texas driver license?
Yes.
Do you have liability insurance in your name? Car insurance?
No, I have a car right now.
Okay, then don't drive. No driving until you have actual liability insurance in your name. Show me that you have it and then we'll let you drive, okay? So what we're gonna do now is we'll have you sign a reset. We'll have you meet with pre-trial for your bond conditions. We'll just have you take a seat until we have Mr. Henderson comes and then we'll all powwow, get you a date. And then after that, you'll be free to go. I will waive your appearance. You don't have to waste your time coming to court, but just stay in touch with Mr. Henderson. He will tell you when you have to come back, okay? So if he tells me he can't get a hold of you, I'm gonna revoke your bond. So just stay in contact and then all will be well, okay? All right, sir, please.
Go ahead and sign for your reset. All right, Judge Mendoza, come on up, page 19.
No, just, hey, Felicia,
Yes, sir.
can you please on his case, make sure no driving without liability insurance in his name? Okay. Is it hot in here? I feel like a small farm animal.
Sweaters.
Mendoza, Your Honor.
Thanks. Miguel Angel? Yeah. Are you Miguel Mendoza? Mr. Mendoza, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Okay.
On November 6th, 2024, the officer was flagged down by a citizen stating they observed the defendant on the feeder road of South Houston Parkway, operating a motor vehicle while hanging out of the window, swerving, and then drove over the curb and came to a stop in the grass.
Did you say he was hanging out of a window?
Yes, the witness observed him hanging out the window.
The driver?
Yes, Your Honor. And the witness advised that the defendant exited the vehicle, threw himself to the ground, began behaving erratically, was having difficulty breathing, was in a panic, was panting, and repeatedly would tighten to a fetal position, and then would straighten out. The defendant advised the officers and EMS that he had consumed cocaine prior to driving. The officer observed the defendant with red, bloodshot eyes, had difficulty forming words when speaking, was unable to stand on his own, was in a panic, and was behaving erratically. Standard field sobriety tests were not administered due to the defendant being unable to stand on his own and had to be transported. A blood warrant was signed and executed.
You don't have the results yet, do you? That's not cocaine, that's something else. Mr. Mendoza, I'm going to find that there's probable cause to go forward with your case. I'm now sending you for a drug test. You were to go take a test and then you're to come right back. Do you understand? If you fail to take the test, if you fail to come back, I'm going to revoke your bond. I will put you in jail. You will not get any more PR bonds. Do you understand? Do you have a valid Texas driver license? Run his license, please.
Yes.
Do you have liability insurance in your name? I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If you have a problem with drugs or alcohol, I'm giving you the opportunity to address it yourself now because you're on bond. If I see that it becomes a problem, we're going to do it my way. And I promise you're not going to like the way that I do it. Do you understand?
Your Honor, his license is eligible.
Any prior DWIs?
No, Your Honor.
Okay. I want to send him for a test. You come back and then we'll talk about your lawyer situation. Right.
All right, let's circle back to page 12. Eden, come on up.
Mom. Hi.
Oh, hi.
Thank you so much for coming. I appreciate it. You're the complaining witness in this case. So you obviously know what happened. We've done probable cause. I think that there is enough probable cause to go forward.
He has autism and
Correct.
sometimes he has behaviors. And so that's what happened. And the only thing,
I don't want to talk about the case because in an effort to protect him, I've got a bunch of DAs here and everything you say, they can use it against him to prove punishment and guilt. So I don't want to do that. I can give you a lawyer today and we can go forward and try to figure out how to go forward. Whenever I have these types of cases, I usually order, no contact or no threatening or harassing. I don't want to do anything yet. What I'd like you to do, if you don't mind, talk to Lori. I'd like to appoint her on your case and then we can figure out how to go forward. I'll give you anything you need, if you need any resources, just let us know. We can try to help you out as much as we can, Okay, Lori, do you mind?
have a seat and I'll come and talk to you. Okay.
So just thank you so much for coming. We'll try to help you out, okay? Of course. Thank you.
All right, Judge, next is page,
Hey, Lori, if you need money for anything, just,
I think you just have to do a competency, on bond competency and then get with Brad. Hopefully,
come on.
hopefully he won't require us to get competency, but I'll see.
all right, Judge, the next one is page 30. Washington, come on up.
You were Jalen Washington. Mr. Washington, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Okay.
On November 7th, 2024, officers conducted a traffic stop on the defendant's motor vehicle after observing it driving with an expired registration as of July 2024 and failing to maintain a single lane, with both left tires crossing over the white marked lanes and the defendant's vehicle failing to signal a lane change. The defendant was the driver of the motor vehicle, and upon contact, the officer observed him with a strong odor of an alcoholic beverage, glossy eyes, swayed balance, slurred speech, and the defendant was slow to answer questions at times. The defendant admitted to drinking, and standard field sobriety tests were administered. HGN 6 out of 6, walk and turn 5 out of 8, one leg stand 2 out of 4. The DIC was read, and the defendant consented to breath. The results were 0.106 and 0.106.
Mr. Washington, I'm going to find that there's probable cause to go forward with the case. How old are you, sir? What do you do for a living?
Currently, I work at FedEx, but I'm in college.
You're currently enrolled in college? Great. Where do you go?
PV. Sorry.
Okay. What are you studying?
Architecture, civil engineering.
Fantastic. Great. It's a big hiccup, man. This can really affect you. You know, anytime you want to get licensed to be an architect, you got to be licensed. All this. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. You're not allowed to smoke any marijuana. I'm going to test you. If I find that you continue to use, I'm going to put you in jail. Do you understand? I'm not asking much. I'm just asking to stay clean. That's it. Do you have a Texas driver license?
Yes, sir.
Do you have liability insurance in your name?
Sir. But I don't have a vehicle.
Do you see if he has a license? Any prior DWIs as well?
There are no priors, Your Honor. I'll run his license right now.
You don't have insurance in your name, then you're not allowed to drive any vehicle. You have to have insurance for, I don't care what car you're driving, unless you have insurance on whatever car you're driving, then you may not drive. And don't come up here and tell me, well, the car has insurance. No, people get insured. Do you understand?
Your Honor, he's eligible.
Okay. Did you want to apply for an unappointed lawyer? You're going to go hire a lawyer? Okay. If you have any issues, if you want me to appoint your lawyer, just come back, tell me, and I'm happy to do it. You know, I mean, money that you have, I'd rather you spend it on school. Are you sure? You don't want an appointed lawyer?
I'll make a phone call to you. Yes.
Okay. Got to understand that if you're going to hire a lawyer, there's a lot of timing requirements with the DWI. Don't sit and wait a month, 2 months, 3 weeks, because you're hurting yourself. You got to do it like lickety split. Do you understand? Okay. Like I said, you ever have any issues, come back, talk to us, and we can appoint your lawyer. Okay. For sure. So I'll have you sign a receipt, Victoria. We'll have you get with Felicia for your bond conditions. If you have a change of heart, just come back.
Yes.
You know? Okay.
Go ahead and sign for your receipt. All right, Judge, that was the last arraignment for now.
Okay.
Counsel for reset.
Eric.
We have one customer on your docket this morning.
Okay.
Last name is Chapman. First name is Desmond.
Bond or
Is on bond for the moment.
for them both.
Let's see what happens here.
So it's only 108 days. What's
It is.
going on?
He has a decision making for dismissal. His phone is disconnected. He's required today. He hasn't checked in yet.
Have you talked to him?
We haven't spoken with him since the last time he was required.
Okay.
The contact information that's on his bond paperwork from when he bonded out, none of those are good.
Do you have an address to send a letter?
We've not tried the snail mail route yet.
Okay, do that. I'll SFBF until next week. If at that time, if you're unable to get a hold of him, then I'm going to revoke the bond. But at least do just the last ditch where you send a letter, you know? Okay. So SFBF 1 week.
1 week?
Yeah.
Thank you, Judge.
Okay. Thanks, Eric. Tony, I'm about to take off. Do you need me?
Well, Judge, yeah, if I could just for one minute.
Come on.
So my client has been on bond since August. Been on bond since August.
Who is it?
His name is Stephen Butler.
Okay,
So
it's not old.
it's not old. The blood came back, it's under 0.08. The state wanted to eval the video. I've asked for the video the last couple of settings. They still don't have it. I know.
There's a problem.
Yes, sir.
It's a problem, guys.
I'm just-
What agency is it, do you know?
I believe it's HPD.
It should be like immediate.
And I have a small portion of the video, but I don't have all of it.
So I guess what we can always subpoena the officer, come to court with the video in hand. If they don't show up, we have a show cause. If they give it to them before the day of the hearing, then they don't have to come back.
Judge, this is HPD. So HPD is having, as far as I understand, they have been having a turnover in their staff. They're creating, not in their staff, but they're creating a whole new system. And now it might take up to 11 months, apparently. Which
The hell it is.
I know, but we just found this
Justice
out.
delayed is justice denied. Absolutely not.
No, I agree, but
Yeah, I
let's
mean-
try to.
And, you know, look, I'm not taking it on you. I'm sorry. It's like my wife gets so mad at me because I do the same thing, right? But it seems like every 2 to 3 years, they're going through one change here, a change there, and then everybody else has to bear the brunt of it, and it's just not fair. So,
No, I agree, Judge. And Morgan did file an escalation request a month and a half ago.
so what we'll do is this, we'll set it for a week, subpoena Deuces Tickum, the officer, to come here with,
The officers,
yeah, all of them. They gotta be here, videos in hand. If they provide it before the day, then they don't have to come. If they haven't, they gotta be here. If they don't show up, I'm gonna have a show cause. And I'll hold HPD in contempt. It's unacceptable. I mean, I'm with you, Tony.
Sure.
so we're rolling it for a week, not roll, but.
Or 10 days. Yeah, 10 days. So subpoena the officer. You got to put a date certain. Don't just leave it open-ended. So you guys pick it 10th day or 11th, whatever it is. They all have to be here with videos in hand.
Okay, Judge,
Yeah,
Okay.
okay, sure.
just let me know what date to
Okay.
pick with the
right.
coordinator. Oh, Morgan.
I have a plea, Judge. It's on Lara.
Okay, I'm ready.
Eliseo, bring him up, Judge.
Do you need a translator?
No, sir, no, sir.
Eliseo Lara.
Come on. Say loud enough so we can hear you up front. Yes, sir, no, sir.
Good morning, sir.
Good morning.
You guys have worked out an agreement where they're offering you 3 days in jail, credit for the 1 day that you've done. Why would we do this? You had one just dismissed not too long ago. Why would we give you another gift?
I think I've learned my lesson.
How? How have you learned your lesson?
Like, just the fact that I don't want to like end up in jail or anything like that.
Oh, you've learned your lesson. Really? The thing is that when we are too nice to people, they end up wrapping their car around a pole the following week. You just had one dismissed. Was it due to a PTI?
Yes, it was, Judge.
You didn't learn a damn thing because now you're back with another DWI and you want me to take this time served so you can go around again? How have you learned any possible thing, Mr. Lara? Tell me. What have you done differently from the first DWI to the DWI you have done now to show me that you've learned something? What have you done? I want you to understand one thing, sir, is that you now are building yourself a house with the priors that you have. At some point, that house is going to crack, cave, and your ass is going to fall through. From now on, you will now be looking at a minimum of 30 days in jail. The proverbial slap on the wrist is gone because now, as a matter of fact, with your priors, you're looking at a minimum of 90 days in jail for anything that you pick up from now on. You will also now be required to pay the fines, fees, and surcharges with this case. And I'm going to tell you, if you don't, every $100 that you owe, you will sit in jail for 1 day. You now will have around $4,000 in surcharges that you will be responsible for. And if you don't, there's going to be a heavy, heavy toll to pay. One way or the other, we are going to reach you, Mr. Lara. And if it's kicking and screaming you, dragging you into jail, all we want are our streets to be safe. That's all we want. Do you understand?
Speak up. Yes, sir.
No more games. Even if you have a sip of alcohol, a sip of wine, you should not get into a car because with your record, you get pulled over. Do you understand me?
Yes, sir.
How much are the fines and surcharges? 3. Is it above a 0.15? What is it?
Yes, sir. It's for the current case, it is a 0.092.
It's a 0.09?
Yes.
I want you to understand that you're going to pay a very hefty fine fees. If it's above a 0.15, it's $4,500 in surcharges, not to mention the court cost. Now it's below a 0.15, so you're paying $3,000 on the surcharge. I'm going to require you to pay also the court costs as well. When you pick up a second DWI, it's a $6,000 surcharge, not to mention all the court costs. So get ready. Not only is it a minimum of 90 days next time, but you're looking at around court costs and fines and fees and around $7,000. How much money have you paid surrounding all this? When all it could have done is one click on your phone, $20. It's a geographical oddity. Don't matter where you want to go with your Uber, $20. Anywhere you want to go. You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you accept this agreement, there's no coming back. Do you understand? It will go on your record. It's going to be there for the rest of your life. It's even there after you die. And I'm telling you, Mr. Lara, you get pulled over and even have the faintest, funkiest smell of anything, you're going to be right back with us. And I'm going to tell you, I have jurisdiction over you for the next 5 years. Do you understand? You come back, it's not going to go well.
Yes, sir.
Get a clue. Hit a button. How do you plead to the offense? Guilty or not guilty? How much of the court cost? You will be required to pay $3,420. I will give you time to pay it because we're not here to break your bank. But I want you to understand that we mean business. And the way that we do it is this way. If you don't pay $100, for every $100 that you owe, it is 1 day in jail. So you can imagine on $3,500 how much time you'll be doing. You understand? All right, good luck to you. I'm suspending his license for 6 months as well, 180 days. All right, Eddie.
Yes, sir, Judge.
Get your boy, man. Hey,
Good morning, Judge. Just told to approach. This is a new appointment, Antonio Perez Orozco. It's a DWI.
and there?
Yes, sir. Because he has a felony also.
Perez.
The DWI is about almost 2 years old and the felony is almost 1 year old.
Martinez Velasquez.
Okay. Looks like he has an ice hold as well. As far as I see. So the ag assault is set for the 22nd. You want the day after? Or do you want more time? Or less time, actually? You tell me.
This is a new appointment, Judge. I don't know anything about the case, so can I just get a normal?
Of course, yeah.
And I assume they're gonna reset him up there because he hasn't been up there in over a year.
Okay. Do you have any, do you think he's gonna bond out?
Not with a nice hold, Judge.
Okay, I guess if you get wind that he's going to, like if family hires an immigration lawyer and they get an immigration bond, just please let us know. But
Yes, sir.
yeah, whatever you want, Antonio.
Thank you, Your Honor.
Thanks, Mike. Hey,
I am approaching on behalf of Russell Singleton. He wanted to see about possibly getting his bond lowered on the misdemeanor.
Singleton. Can you bring up Mr. Singleton, please?
And this is a DVD case, Judge.
Okay, but they're not, are they?
I've emailed DVD. I understand that defense needs to approach. He has other cases, so I told him to come up with it.
Right.
I did email DVD, Judge.
Okay. I mean, we can just go forward. It's not a big deal, you know, just a bond here and see whether to reduce it. I don't know. Eddie?
Yes, sir. I forgot, Judge, he has an interlock. I need to get an interlock removal.
Yeah, for sure. We got you. Eddie, I don't know if it's with Victoria. I think it may be with Victoria.
Singleton, Your Honor.
All right. Morning, Mr. Singleton.
Good morning, sir. How are you?
Been great. You know, it's Thursday, Friday Eve. Ready for the weekend, you know?
Yes, sir.
So
See, you have the decorations.
thanks. Well, it's all them.
Yes, sir.
Your lawyer has asked for me, or is asking for a bond reduction in your case, but you know, my concern, and I guess my very, very primary concern is public safety. You've got a lot of serious charges, and from what I see, your bond is now at around 200,000. You've got 2 open aggravated assault cases, and you got an assault of a family member with us. Our bond is set at 5,002. What did you guys want?
Possibly looking for a PR bond, due to the fact that his other 2 cases are extremely high. We believe that he should be able to bond out on that. We have been talks, he has been in talks with some family members regarding possibly coming up with money for the other 2 bonds, but reducing it here would possibly help him out regarding the overall amount that he will have to come up with.
Well, so my concern is, it looks like in September, he had an aggravated assault with a deadly weapon dismissed, right?
I believe that case got filed twice, and they.
So what's going on with the cases upstairs? And is it the same complaining witness as our case?
So there's two complaining witnesses on those cases, Judge. And it looks as though it's a different complainant with us.
Is there a weapon involved? Is it a shooting?
On the aggravated assault with deadly weapon, Judge, so in the felony cases, there's 2 weapons involved, a machete and a gun, a 9mm handgun.
Does he shoot at them? Does he shoot?
At them. So the state would be opposed to lowering bond, Judge, given the severity and the propensity to violence that felony cases also show.
Oh, I think I remember this case. It's about a neighbor. And it's either about like a fence or it's about some bushes or some, right? So,
So the state's concern is community safety, Judge. So for those reasons, we would be opposed to lowering his bond.
Even if it's not going totally to a PR, if it's possible to do 2,500, that was great.
I don't know, you know, I mean, we gave you a PR bond in this case. I let you out, right? And then you go out, you allegedly have these now 2 aggravated assault cases where in one, you point a gun at someone.
Shoot them in the head.
And if I remember, it's something so trivial over. Don't talk about the cases though, because I don't want you to.
I wouldn't incriminate myself or anything, but I live by truth, sir. And these people stole stuff from me.
No.
But, Mr. Singleton,
Not that.
but there's a certain way, when someone takes something from you, there's a certain way that you got to act.
I'm the one
You
that
know?
called the police, Your Honor.
And that may be so, but there's still a certain way to act, right? And if you,
Washington?
refresh my memory, because I just don't remember it.
I can read.
Yeah, go for it. Just a brief synopsis.
On or about September 7th, 2024, complainant Sarver his truck when he was awoke by the defendant knocking on the window with a 9mm handgun. The defendant then pointed the gun at complainant Sarver and demanded that the complainant get out of the car. When complainant Sarver got out of the car, the defendant stated that he would shoot the complainant in the head. Complainant Sarver advised that prior to coming home from work and having his incident with the defendant, the complainant too was also involved in an altercation with the defendant earlier in the night. The second complainant stated that an altercation arose between him and the defendant, which resulted in the defendant punching the second complainant in the face, causing him pain. The second complainant punched the defendant back and the defendant ran to his house. Shortly after, the defendant returned with a machete in one hand and a stick in the other and was calling out for the second complainant to come out to the street. So it seems as though he pointed a gun at complainant 1, and then in complainant 2, he punched him, and then when the complainant punched him back, he came back with a machete and a stick.
Sorry, Mr. Singleton, just too dangerous for me, man. I can't give you a PR bond. I already gave you a PR bond. We let you out, and then you pick up these 2 serious cases. You know, if we give you a PR bond now, if we were to lower it, I mean, what's going to happen? You're going to pick up a 4th case? We're trying to prevent that from happening, you know?
Order in the court.
Yeah, speak.
But not about the cases, okay? Just because I don't want you to hurt yourself, you know?
I understand, Your Honor, but I don't recall you ever giving me a PR bond, sir.
We gave you a PR bond on, in our case, we gave it to you on 8/12 of 24. I gave you a PR bond. We let you out of jail. You know, you had certain conditions that you're supposed to follow. No weapons, no contact with the complaining witnesses. And so here we are with 2 very serious cases. If you're able to bond out, and if you have someone, come back, talk, perhaps we can.
My fiance.
No, but
the person who this is.
You're your own worst enemy, Mr. Singleton, really. I mean,
I'm
you're your
sorry.
own worst enemy.
I guess it's the military.
Well, don't blame it on the military. They're choices, right? And
yes,
sometimes choices are made such that.
I know I need help, Your Honor. I'm not saying I don't need help. However,
the problem is that you can't do that after the fact.
I understand.
You got to recognize it before the fact, before it balloons out of control. That's why, you know, and it's not our first rodeo here with you. You've had prior assaultive cases like this. So you have to understand that when you get these feelings, these urges that you're going to lose, just You got to try to take care of this beforehand. Now, why don't we have him TRASed? Okay, let's see what it says. Let's see how to go forward. You know, if they say that there's treatment that's, you know, I have options available to help you with these issues. And I'm willing to help you and I want to. Yeah, we will do it. But the first things first is I got to have you evaluated to see how we go forward. And if you let me do this, and if you're honest with me, Mr. Singleton, let's try to work something.
I will be.
All right. Can you set up a TRAS for Mr. Singleton? Yeah, please. I'm going to set you for an evaluation. I'm going to have you speak to clinicians. Be honest.
I will.
We'll come back in a couple days. Today's what, Thursday? Come back on Tuesday. Let's talk about how we go forward. Okay?
Yeah.
Look, this isn't the be all end all, but let's see how we go forward. You know, that's why God put eyes in the front. So we go forward. We don't go backwards. All right? Okay. All right.
Thank you. Appreciate it.
Stay. Okay? You know, Alan, you know, depending on what that TRAS says, it may also help with what upstairs to try to work out some kind of treatment program so that, you know, because it's all just anger, right? Yeah.
That's the first time I've seen it actually. Like that, so it makes
It may be worth exploring because it'll help, you know, hopefully upstairs as well. Yeah, thanks. Yes. Hey.
Judge, I'm here this morning on Hetman Villatoro. He is in custody.
Okay.
Yeah, this is a case that allegedly occurred in 2020. My client was deported by immigration in 2020, and he's now back in. And it's my understanding that the state is missing a complaining witness, and they'd like to evaluate the case. And in an effort of doing so, they want to contact a potential witness so we can move forward with the case.
As much time as you need, you can have it. I get that it's old, but it's okay. If you need, you know, however much time you need, you can have it. He has an ice hold, so I don't think he's going to be able to
Check
go
with the
anywhere.
state to see how much time they need to contact the point complaining witness.
Just however long you need, it's yours.
Thank you, Judge.
Thank you, Juan. Hi, Doug. What's up, man? Happy Thursday. Yeah, of course.
I've got an off docket matter, Your Honor, a gentleman that has court on Monday for an arraignment, but he's scheduled to be out of town for work purposes, and I brought him
Today?
today.
Yeah, let's do it.
So, okay.
You wanna bring him up?
Mr. Heath? And it's,
I need to give you, it's an arraignment. I need to give you a cause number. And then on that other case you're asking about? We're doing a PR bond, right? Vic, we're doing a PR bond on that out of county, right? Okay, 1,000. Yeah.
What's this case number?
Your cause number is 253-8206.
Mr. He? Sir. Good morning, Mr. He. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, sir.
Okay.
On November 11th, 2024, officers conducted a traffic stop for a defective license plate lamp in Harris County, Texas. The officer made contact with the defendant, the driver and sole occupant of the vehicle, and observed a strong odor of an alcoholic beverage, watery bloodshot eyes, and disorientation. Standard field sobriety tests were administered. HGN 4 out of 6. Walk and turn and one leg stand were not administered due to the defendant becoming belligerent. Walk and turn, prior to termination, they had detected 1 of 8 clues. The defendant read the DIC and refused to provide a specimen. A blood search warrant was obtained and executed.
Any prior DWIs?
No, Your Honor.
Okay. Mr. He, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. We will randomly test you. If we find that you consume alcohol or drugs, you will go to jail. And that's it. Do you understand? Do you have a valid Texas driver license? Do you have valid liability insurance in your name? You may continue to drive as long as you have both, and Mr. Murphy will tell you if it does become suspended. If it becomes suspended, you may not drive. Now, because you have a lawyer, we will waive your appearance. You do not need to waste your time coming to court, but you must stay in touch with Mr. Murphy, and he will tell you if and when you have to come back to court. If he tells me he can't get a hold of you because you're gone and you're not responding, I will issue a warrant for your arrest.
That won't be an issue, Your Honor.
I don't think it will, but we have to put you on notice of what we expect and what, what happens when you start acting up. So we will have you just sign a reset with Victoria. We'll have you get with Fleischer for your bond conditions, and then you guys are free to go. Okay?
Judge, thank you very much.
Aaron. Hey.
Looking on Mr. Coffer on bond, first name Jeffrey.
Okay.
His appearance was required, Your Honor. He just started a new job. I'm just trying to get a couple weeks and we're gonna set it for a plea.
How is it required?
I honestly don't know. He is working though. I don't want
Because normally it wouldn't be, just that there must have been an issue, like he's not getting in contact with you.
I mean, I'm talking to him. Coffer. Coffer's not in jail. I talked to him yesterday.
Vic?
One second, because I saw him also showing up in jail, so he might be just being put in after midnight.
I'm showing him on bond too.
I'm showing him on bond too, but I feel like I've always had this issue with him since he's been on bond. Like, it says he's in jail, but he's been on bond. I mean, I can.
And I'm not showing online that he's in custody. But you talked to him on the phone?
Yeah, I talked to him on the phone yesterday and this morning.
Or this morning you talked
Yeah,
to
I
him?
talked to him this morning. Yeah.
Huh. I mean, unless there's an issue why we need him here, we don't need him, right? Do you have an offer on the case?
I do. It's gonna be time served and he's gonna plea. I mean, he's gonna take it.
That's it.
I mean, I'm sure.
Look, I don't know,
Yeah, he has. I don't think this is the most important issue to him in his life right now.
Okay. Yeah, it's not old. If you just want to reset, Aaron, it's yours.
All right, thank you. Appreciate it.
And then, it's young enough that if you still want to waive it for the next one,
All right,
you can do that too.
Appreciate it.
For sure. Hi, Hugh.
John L. North for a plea.
Okay.
Sir. I also have, after this, I have Tony Curry. Order hearing on that.
In custody? What's the last name?
Curry.
Curry. So basically, what I see is that he picks up a theft case, they let him out, the week later picks up a trespass, right? And so this time they didn't give him a PR bond. Am I right?
That's my understanding of it. I think it's like 3 days later that he picked up a new charge.
Let me read this to you, okay? This is what the magistrate says. It says, defendant on GOB for theft, shoplifted blenders, cleaning wipes from Target, close paren, prior criminal history for misdemeanor theft, shoplifting, blenders, and camera from same target. Another theft from target, where another theft for blender, beard conditions. Dismissal was in the plea deal. Now, a new charge, defendant at TJ Maxx, shoplifting, detained, previous trespass warned, defendant not obeying, NFC of bond, no NLVs, still shoplifting in same area despite being on bond for one theft. The CX for MB theft from 2 weeks ago. Public safety concerns, indigent per AFC. That's why they didn't give him another PR bond, so. I don't know what you want to do.
He told me he does stay around Eldridge and that he could take a bus to get here, but.
Bring him out and talk to him in a bit. If you want.
Yes, yeah, sure. Let's see if we can.
This is your plea? So we're pleading on the trespass and it looks like, does he have 4 open cases?
No, he doesn't have any open cases.
You sure?
Yeah.
Alex, on Mr. North, do you see if he has 3 cases or 2 or what?
I only see the trespass, Your Honor.
Good morning, Mr. North.
Morning.
Why don't you show up to court?
I'll call it.
You know, if you show up, we have resources that we can help you. Good things happen when you show up to court, and when you don't, you know, this is. On Mr. North, how many cases do you have open? No, well, that's not true. Look, I have 2 other terroristic threats that are in one sentence. Look.
No, those are closed, Judge.
Yeah, that's all exposed.
That was closed on 2020.
Yes.
Okay.
Council for reset.
Oh, the other one. Okay, so the agreement that you have worked out is 3 days in jail, credit for the 21 days that you've done. If you pick up a case again, show up. We can help you and good things can happen if you show up. Do you understand?
Yes, sir.
We can help you with food, money, services, housing, you know, Social Security. If you show up, good things happen, man. Just come back. You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront, cross-examining accusers if you're not a citizen. There are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal once you accept this agreement. You can never change this or undo this. Do you understand? How do you plead to the offense? Guilty or not guilty? I will find you guilty. I'll sentence you to it. Good luck to you, sir. Justin. I'll give you the same date if you want it, and we'll have him sign here momentarily. So, I'll have her do it next. What's the name?
Joseph.
I don't see Joseph.
Joseph
Thomas? Okay, I got it. Okay, Hugh. Good morning, Mr. Curry. How are you? Your lawyer is asking me to give you a PR bond, or is that what you want? But the problem is that, shh. Mr. Curry, if you want me to give you a PR bond, you got to talk to me. Okay, we give you a PR bond and you continue to pick up new cases. You continue to do things where we're asking you not to do, we're asking you not to do things, and it continues to happen. You said that the last time. Where are you staying now? Who do you have in your life that's willing to help you out now? I can't, you need to speak louder. I'm hard of hearing. So if we were to let you out, you're just going to be on the street?
Staying over by Eldridge. Okay.
The last thing I want to do is give you a PR bond and you just end up on the street. That is setting you up for failure, and I don't want to do that. If you have someone that's willing to take you in, mother, father, brother, cousin, aunt, uncle, I'm happy to talk about it and getting you a place to go to, but I don't want you out on the street. Nothing good happens on the street. So how old are you? Okay, where's mom and dad? Shh. God. Where's mom and dad? Why are you here and not Mississippi? Speak louder, man. I can't hear you. And what happened to that job? So what did you end up doing? Just staying on the street then? Who else do you have here?
I had someone I could call and get in touch with, but I had to get in touch with.
I am willing to give you a PR bond if you have somewhere to go. I'm not letting you out on the street though. If you have someone's number, name, any kind of way that we can get in contact where you have a place to put your head down at night, I'm willing to let you out. So you got to work with us to find out how we can find you a place, and then we can get it done. But the street it's not a good place. It's too dangerous, and I don't want you to have to resort to doing things that you shouldn't be doing. So Hugh, let's comb his paperwork to see if there's something else that we have in there, but not to the street. Anywhere else, I'm okay with it. But,
Sure.
yeah.
Get up to a home or some kind of a house.
Yeah, absolutely. Okay, all right. Mr. Curry, let us know, man. We did more.
Martha Simpson.
Hi, Ms. Simpson.
Hey.
Ms. Simpson, you're charged with assault and bodily injury. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement. They're offering you 3 days in jail credit for the 10 that you've already done. Is this what you want to do, ma'am? It's going to go on your record. It will be there forever. You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this, you can never change this. You understand? How do you plead to the offense, man? Guilty or not guilty?
What'd you say? Not guilty. No, that's not correct. Did you hit the lady?
Guilty, man, guilty.
Did you hit the person?
I suppose it, but.
Did you bite?
No, she pushed her with some force in her face.
Remember, even if you grab someone and it's hard enough that it hurts, that could be one too. If you spit on someone, could be an assault too. So are you guilty of the offense, man? Okay, I'll follow it and I'll send you to it, ma'am. Understand from now on, it's a minimum of 90 days. So you got to be careful, man. Okay. All right, man. Good luck to you. Okay.
Okay, thanks.
Lori, how did it work with the other gentleman? Is he all right?
We have to do a confidence on, so I'm waiting to get the, the.
So he wants a comp? Oh, okay, Sam. Coming up, Sam.
Good morning, Judge. I'm here on Tracy Pope.
Last name? Pope. Okay. Bonder, yeah. Bond. Okay.
Yes. She is, it's a required appearance today. She's not here.
Oh, I remember Miss Pope.
Yes.
Talk to her lately?
It's been a couple of months. I know where she's at. She's in Galveston.
In jail? Why?
I think it's a DWI charge. I understand.
Yeah, I mean, I can't just. That was the one, do you remember her? She was the one lady that we had to sit down, that was just all frazzled. Right, the panic attack, right.
So I know they've made, like, on the felony, she's got a felony case here. My understanding is that they've made an offer to dismiss the felony if she pleads on this one. I frankly think that's a horrible deal because I don't think they can prove either of them. They just did the rip call on this one for the first time. She doesn't want to pursue charges. I've known that for quite some time. The sticking point is that she's in Galveston, so we can't really.
I'm revoking her bond. I can't. You pick up a DWI in another county. Alex, can you run her NCIC?
Her NCIC, right?
Sir.
What has happened since May? Has she picked up anything else other than the DWI? And was it a felony or was it a misdemeanor?
I see in Galveston, there's a DWI third felony. And that's the last thing since May.
When was that? When did she pick that up?
On July 5th, Your Honor.
So the sticking point for me is that I think we can come to some sort of an agreement on the cases here, but like I said, we can't do anything with her.
Right, she picked up a felony, so I'm revoking her bond and I'll set it at 5,002. And then I guess it will place the hold. Or do you want a bench warrant? Get her here?
Not right now. Let me talk to the felony attorney and see if that's something that they're interested in. I had talked about that at one
Perhaps
point.
there's a global resolution, you know?
Yeah. I do think that the cases here would end up going away if she does some TDC on the felony.
Sure. Okay, so do you want to stay on it or do you want to withdraw?
I'll stay on it.
Okay, just, we'll keep you in the head.
I'll check.
I'll call you when we get her. We'll place the hold now and then. Yeah, okay.
It says she's awaiting trial in Galveston, so if.
You know, I remember I had a case in one of the courts over there. The first day I got there, you were placed on the trial docket. The first day. We must have gone through 25 trial settings. And we never even, just literally every time, and you'd have to sit. So.
One's at 20,000 in Galveston, so she's not getting out.
Have you talked to mom?
They
can't afford to bond her out, I guess, huh? Okay.
So she's gonna have to sit. They can't get her out.
Okay, well, maybe she'll, you know, who knows?
Yeah.
Okay, Sam.
Thanks.
Okay, counsel.
Thank you so much for coming.
Oh, it's not a problem, Judge.
I was here yesterday and I think that he was ready to just.
Yeah, and I think that I was kind of looking at as far as the drug test. I called Mr. Best, and I know that there is somewhat of a disconnect. I was kind of letting you know as far as what the outcome when we had an earlier setting for Mr. Best, I believe last week, and
He was clean. He's clean.
He's clean?
Clean.
Okay, great. Okay, well, I don't even need the approach.
He's
I was-
fine. No,
Okay,
no.
great.
Clean.
Well, we've already worked out a PTI. He's gonna do anger management with dismissal, so.
Okay.
No need to approach him.
He wasn't. It's old though. It's 240 days. So is it just a short, like a 3-hour, 2-hour class?
I'm hoping he can do the class, Your Honor. But it's only a 2-hour class, so that's my only option, my only hesitation is that.
If he, for some reason, doesn't have a computer, we can probably find one around here and hook it up somewhere.
That might be just.
You know,
We find out, Judge, because if that's the case, then I would like, and then that might be something he can do right now.
Problem is though, is that I can't leave him alone with it. That's the only issue.
He can stay here and just complete.
Right, but someone has to be with him.
Sure.
That's.
Let me see if he has that option, Judge, and I'll go from there. But thank you.
Sure.
All right.
Anna. Anderson. Tell me about Mr. Anderson.
So there is a bond violation.
Come up, Mr. Anderson.
However, we worked out a deal with the state.
What?
And to reduce it to a first and then 12 months probation.
Okay.
We have the plea paperwork in your.
Are we doing that now?
If you'll allow us.
Sure.
Okay.
Is this a foregone conclusion that you're going to go into rehab, Mr. Anderson?
Yes, sir.
Because I'm going to tell you now, this is now makes 3 bond violations. The next time you even go next to alcohol, I'm going to put you in a rehab facility.
Yes, sir.
Understand me. I don't care what you're doing. I don't care what it is. You come here kicking and screaming. If I find that you use while you're on this probation, I will amend conditions to put you in a rehab facility. And you could be in there for a very solid year, depending on how well you respond to treatment. You understand?
Yes, sir.
Okay. It's up to you. Do you want to do it? I'm game.
That's his decision.
Yeah, it's up to him.
Sure.
Okay, done. Do it.
You need to do the.
Are you, I'm sorry, are you ready to go? Okay. Mr. Anderson, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement that they're offering you 180 days in jail to be probated for 1 year. As part of the conditions, you will do a DWI repeat offender. It must be a repeat offender DWI education class, okay? 1 victim impact panel, a TRAS to see what other conditions you may need. You must fulfill those conditions while you're on this probation. No breath test refusal. So if you're pulled over in a car and an officer asks you to submit to a breath test, you must take the breath test. No drugs, no alcohol, guardian interlock, 16 hours of community service. Do you have children, Mr. Anderson? What does he have on now? Does he have on a guardian interlock? What does he
He has
have?
a Scram right now.
Okay, I'm gonna keep that on for now because I'm suspending his license for a year. And I want to make sure that he's not consuming alcohol at all.
So you wanted to have the Scram and the interlock?
Yeah.
And that's with the free trial, so it'll have to be taken off and then new one will be put on from.
Okay, no, I don't want to take this off until he puts the other one on though.
And Judge, just a reminder, this is a drug. I don't know if that changes your
No,
decision.
I have here that he consumed alcohol. So he's still using. I don't care how minute any alcohol that you have, Mr. Anderson. I'm telling you, you consume even a smidgen of alcohol, you will be looking at a motion to revoke that gets filed, and then you will be perhaps and very possibly looking at a rehab facility in the jail. Do you understand? I would like him TRAS'd today. Since he's here today, he gets the TRAS today. And in the TRAS, I wanted to make it known that he has, this is his 3rd bond violation, and that he has a consumption of alcohol 3 days ago, because I want that part of their analysis and how to move forward. So what part of what you are agreeing is that you are agreeing to whatever conditions. What conditions are being done by the TRAS. So I don't know what they're going to assess. They may assess intensive outpatient treatment. They may assess supportive outpatient treatment. They may assess something else. Whatever they assess, you must fulfill those conditions. Do you understand? The other thing that you must understand is that even though they're reducing this to a first, and the reason that they are reducing this to a first is to a first DWI is to bypass the mandatory 5 days in jail. That's why this is happening now. But I want you to understand that for the next 70 years of your life, you have all these charges on your record. So if you get pulled over from now on, even the slightest smell of alcohol, you will be in felony court looking at a minimum of 2 years in prison, a maximum of 10 years in prison. Do you understand?
Sir.
So I wouldn't even step near a car if you've had something to consume, or if you've had any alcohol whatsoever. Even if you take too much NyQuil, that will cause a loss of the normal use. You understand? You're giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you can never change this or undo this. Do you understand? How do you plead to the second offense, DWI, being reduced to a first? Guilty or not guilty?
Guilty. Guilty.
Is it above a 0.15? Is this above a 0.15? Morgan? Do you know?
No, Judge.
Sorry?
No, Judge. it's-
No? All right, I will find you guilty. I will send it to you the agreement. What do you do for a living, sir?
I build valves for oil rigs.
And how much money do you make a month?
About 2 a month, 2,000 a month,
How much do you really make a month?
25,
How much do you really make a month, sir?
2,500.
Order in the court.
I'm not going to assess court costs, but I don't know about assessing the surcharges. That's why I'm asking these questions.
The surcharge shouldn't be assessed on a probation. It's only on a final conviction.
This is a conviction.
It is a conviction, but
It is a conviction.
it's not for DPS. They don't consider it a final conviction because,
It is, though. It absolutely is. We're not doing a deferred.
right, it's a final conviction for the purposes of it being on his record forever, but not for the surcharge.
Okay, so I'm going to take a look at that now.
Okay.
I don't believe that that's the case because I'm going to issue the surcharge on him.
Okay,
Okay, if it's not, I mean, I'll take a look now after it dies down,
okay,
but I don't think that's right. But, and, I mean, you'll be around, right?
yes.
Okay, give me a second. Let me thin out the line and then we'll talk. All right. Take a seat, or I'm going to have you sign all the paperwork.
Yes, sir.
Watch yourself, Mr. Anderson.
Yes, sir.
No tolerance. All right, good luck.
Sit down.
There's an open container. That's a minimum of 3 days in jail. Did you want me to abandon the open container?
I'm okay with abandoning it, Judge.
Okay, all right.
Okay.
So what's going on?
I'll let you finish, Your Honor. The defendant ended up calling us back later in the afternoon, but that was after.
Are you guys happy?
Yes, sir.
You want to withdraw it?
Yes, sir. I do.
Done.
Okay, perfect. Thank you.
Okay, for sure.
And Judge, before we're done, there's a companion case that's being dismissed as part of the.
Right, and I see that the gun case will be dismissed. Oh, what about the gun, though? Are you guys forfeiting the weapon?
I believe that was part of the agreement.
Okay, the weapon will be forfeited. All right, it'll be
Order in the
coming.
court. It's
Do you
getting
want
too loud.
do you want him to speak with probation?
Yes, please.
Judge, I just had a question. You want us to do Scram on consumer misdemeanor?
Correct. Yes.
Is it all right if I take some of our time? About yourself?
Of course. Yeah, of course.
Judge, see my attorney, is it okay if she stands up here with us?
Sure.
Thank you, Judge.
Hi, how are you?
Good. How are you?
Welcome. Who do we have here?
We have Miguel Gonzalez, Your Honor.
Okay. Good morning, Mr. Gonzalez. Mr. Gonzalez, you were placed on probation for driving while intoxicated. It is now alleged that you have violated that probation, specifically in that I guess we're not gonna go forward on the Berg habit.
Correct. We agreed that we're going forward on the 3 technicals, not the first 2 new law violations.
Okay, I guess to make it easy, we'll just go forward on the failed to perform the community service hours as ordered. Is it true or untrue that you violated your probation?
True, Your Honor.
I will find that it's true. I will now revoke your probation, sentence you to 75 days in jail. I will give you credit for the 8 days that you've done. Did I suspend the license?
It wasn't the first time?
Because when they get on probation normally, unless it's a second, so was this a first?
It was originally filed as a second and pled down to a first.
No, you're saying I didn't?
You did.
Okay, I have to now. I'm going to suspend your license for 180 days. Mr. Gonzalez, don't drive until you get a license. Otherwise you get into a car. You're rolling probable cause, man. You understand?
Yes, sir.
Okay, good luck with you.
Thank
All
you,
right,
Judge.
thanks, guys.
May I be excused?
Yes, ma'am. Thanks. Okay.
Salazar, Your Honor.
Good morning, Mr. Salazar. How are you?
No good. How about yourself?
Friday Eve. So, you know.
Like everything worked the felony out, Judge. He pled guilty to the felon. I believe they reduced it to a less included, reduced it to a misdemeanor.
Oh, they did?
Yeah. And,
Okay, so it's not a felony. Good.
but they're deported. They've already got the deportation orders in on it.
Really?
Yes, sir.
Yeah.
These are things that you got to think about, man. When you're not in this country with permission, you have to think about these things. Because when you start acting like a fool out there, they can put you in immigration custody and then you're stuck like Chuck and then they'll end up, sending you back. What's going to happen now? Is it from Mexico? Where is it?
Yeah.
Yes, sir.
Yes, sir.
So do you have family there? At least when you get there?
Yes, I do.
Okay, well, that's good.
Yeah.
The only thing I'm gonna tell you is that if you want to come back here, do it the right way. You gotta ask for permission first. Don't just come here. Because if you get caught with the feds, you could be looking at serious time in federal custody, years and years. Don't just come. Do things the right way. And when you do that way in life, good things happen, So what are we doing here?
We're pleading true to the MRP violation, Judge.
In essence, I mean, there's nothing we can really do anyways, because you got the ice hold, so it's.
We had 40 days before they come pick him up.
All right, did you agreed to voluntary departure? Is that what happened?
Yes, sir.
Yeah, okay. All right, so Mr. Salazar, you were placed on probation for assault of is it a family member, right?
That's correct, Judge.
So there is an affirmative finding.
Yes, sir.
You have to understand that you can never own a gun or ammunition as a result of this. There's an affirmative finding of family violence. So if you ever pick up another one of these cases, you will be looking at a minimum of 2 years in prison, a maximum of 10 years in prison. A second assault of a family member is a third-degree felony. Do you understand? The other thing you need to understand is that you now have had already a felony reduced to a misdemeanor. The likelihood of them doing that again, it's like lightning striking twice. You understand? Is it true or untrue that you violated your probation?
True.
I will find that it's true. Let's do that on allegation number 15, that he tested positive.
Yes, sir. Your Honor.
Not on the
Law
violation.
Yes, sir.
All right, I'm going to find that it's true, Mr. Salazar. I'm going to sentence you to 90 days in jail. I'll give you credit for the 78 days that you've done. Like I said, there's an affirmative finding of family violence. You can never own a gun or ammunition as a result of this. Just be careful, man. If you want to come back, do it the right way. Ask for permission first. All right? Good luck.
Thank you.
Thank you, Mr. D.
Yes, sir.
All right. Hey, you ready?
I think so.
Tell me.
This is in regard to.
What's the word, Thunderbird?
I got somebody's phone. Oh,
I can tell us, come up.
Thank you. I'm sorry.
Everybody, please, just keep it down. You know, guys, we're talking about Akin Pelu. Is he on the docket today or no?
No, you just want us to come back.
Let me give you a cause number, guys. And
I remember this case, Judge.
I'm at a loss of everything, you know. You're on 2 different felony probations, both of those for driving while intoxicated. Both of those are felonies. So it's not only do you pick up 1 DWI third, but you pick up a second DWI third. Get on probation for both of those. And now you've picked up here, driving on a suspended license. We ordered you, number 1, not to drive, and number 2, not to consume alcohol. That's all I've ordered you to do. Just don't consume alcohol and don't drive. Has anything happened upstairs?
Well, Your Honor, to be fair, I think the integrity of the machines are in question. 11/7. So when he picked up the first one on 10/29, you told him to test Monday and Thursday.
You mean picked up what? The machine?
No, when he when you thought it was a tamper on 10/29, he started testing Monday and Thursday, which in this case helps us. So on Thursday, 11/7, he was here in court where he tested. He tested at 12 o'clock. At 11 a.m., they got a tamper and a sign of alcohol. However, he tested clean with the test you told him to take that day. So which tells me that that machine's integrity is not correct. So if the integrity, and he's maintained that he has not been drinking either time. Every time we did the court, I promise he's not drinking. So if that machine is saying tampering alcohol and he goes and tests on 11/7 at 12 p.m., an hour after the tampering in alcohol, then he may be telling the truth. And I understand what we're dealing with, but he has tampering, sign of alcohol, and then it dissipates and there's nothing there. So
I'm on the same page as you as far as I never want to punish someone who's never done or who has not done anything wrong. That's not, we don't do that. We're the exact opposite. I mean, I scrutinize every single thing that Michael does, every case, every probable cause, I don't think I scrutinize the hell out of it. But at the same time, I also do that with people that are in front of us as well as people with charges, right?
And Your Honor, and to say off the record, I know that you do that. I know that you are a judge that will be very fair in these situations. So I'm just saying that.
So he takes a urine sample. It looks like on 11. What day was it?
11/7.
11/7.
I think the sample was taken around noon. He did 2 that day, 1 upstairs and 1 downstairs. So 11 and 1 o'clock, he had to do 2 different samples. 11, I think 07, they say he tampers and a sign of alcohol occurs. So he was here in court, but still have 2 urine analysis around the same time as that he.
Alicia,
Yes,
do you
Judge?
have a test for 11/7? Because I don't have it.
Yeah, so it's probably not in those records because right now it's just presumptive. It was presumptive, but it's negative. So nothing came back. I have it on my end here. It should be.
What time was the positive for alcohol on 11/7?
For the Scram report? Let me see.
I thought it was like 11 a.m.
Sorry, normally I don't look over those reports because I don't know how to use them, but I will try to figure it out.
And Judge, I might have an unupdated report. The only BVR I have here is for a Scram violation from October 30th.
Yes.
Was there another violation?
Yeah.
Okay.
So there's a violation technically pending on our end because he was coming in that day, so I addressed the violation. And so they were waiting to file it to see if judge wanted that to be filed because he was going to address it in court. And that's what we're discussing from 11-7. So that violation is pending a DVR because judge is taking action on it already.
Do we have a?
I could have sworn you said that there's another presumptive alcohol.
On 11-7.
On 11-7.
No, there's a presumptive negative for the Paws test that he took, our rapid test.
No, yeah, right.
On
I know that
11-7,
one.
it was a alcohol detected, but. can't
What
be
time was that?
confirmed. I'm trying to read the report. but
Because
I
that's,
don't know how to read
that's,
it.
we've got a.
So I got it right here from Brittany Gordon. The defendant order was obtain a Scram device. The defendant's Scram device has confirmed one tamper event. The tamper event occurred at 11-7 at 12:42 p.m. Now he was taking the test at 12:30
Hold on.
p.m.
Saying it was 11-7.
At 12:42 p.m. Got this email on November 11th. It went to everybody in the court. And alcohol was detected during the tamper. However, alcohol cannot be confirmed as consumption because of the nature of the tamper.
It began at 2:25 p.m. and returned to baseline at 8:04 p.m.
We also took another test with you guys on 11-7.
Yes, that was at 12:47, I believe. Let me double check.
What? So at 12:42, he tests positive for alcohol, and then at 12:47, he tests negative for alcohol. Am I right?
It was, sorry, one, two, it was Tuesday, October. I'm sorry, Judge, respectfully, I have no idea how to read Scram results and everything that's in my email, but I can check on the drug test for you.
Well, so the 11-7, we have the email on November 11th, okay? Then if you go to the email she just sent me, it tells you when the lab test was submitted. Hold on. You just sent me this email. And this email from Average Size Individual Screening Report on 11-7, it says that it was one of the collection times was at 12:08 p.m. on 11-7, 12:24. He did negative. So that means while he was in court, he would have to drink. But then he took another test after that. I don't know what the other test is at. What I'm saying, Judge, I'm just saying this whole, if we were in trial right now, the whole integrity of these machines would be in question right now, because in the previous test, because the same exact message that we got on 11-7 was the same exact message that we got on 10-29. Scram tamper, alcohol cannot be confirmed, same thing. So what I'm saying at this point, he has maintained to me, and I know he's messed up numerous times. He's maintained to me that he has not touched alcohol since his last situation. He did drive, he's wrong for that. But these new testing procedures that he's got,
What do you mean he did drive?
that's why we're in here, because he was driving.
So due to the charge, though.
Yeah, he did drive.
I hope to God that you're not driving this driving.
No, I'm talking about due to discharge, while we're back in your court.
Okay.
Judge, I don't have any of those emails. I think the best thing at this point is we can set this off for a bond hearing, and I can bring Ronald Grant here to clarify all of this with all of us, because none of us are experts. We don't know how to read the report. I know what defense is saying, but I I can't even tell you the veracity of anything that's happening because I don't even have these emails.
Yeah, so like,
So I can subpoena Ronald Grant. We can do this next week. I can get it done.
let's not disrupt other people's lives. It's not necessary.
Sure.
He is saying that we have a test, and I mean, what Mr. Evans is saying, test 11/7, the Scram at 12:42, there's a positive, but then 7 minutes later, there's a negative when he goes up there to test. The machine's obviously messed up if that's true.
Is that what you're saying, Felicia?
And then I've also noticed on the Scram report, I asked them, because again, myself, I cannot acquire this, I have to have it provided from our case managers and the provider of the device. But the Scram report, the only one that I'm seeing attached to the email is for the DVR that was filed for the 29th, but I'm not seeing the one from 11/7.
So we don't have a Scram report from 11/7.
We have
It's not attached in the email, but we do have the rapid test when he was on site.
The rapid's negative.
Yes, and then we were informed, like I informed you yesterday, of the pending BVR violation for the 11/7
Hold
at that time.
hold on. So Judge, we don't even have the Scram report. We don't know what the presumed blood alcohol content was. It's very possible that if he had a very low blood alcohol content or breath alcohol content, that the Scram detected that he could have come to court, taken a test and gotten a presumptive negative because it's already been eliminated from his system. That's why I'm saying I believe we need to get that Scram report from 11/7, get what the tamper is, have Ronald come up here and tell you what's possible or what's not possible, because he's the expert, and I get what defense is saying, but he doesn't know either.
But
I don't think.
let me respond to that. What we do have is a test that happened at 12:07.
Right.
And I can show you that one. So even if we don't have the one that she spoke of at 12:47 that she referred to, we have a test right here, which will make us have to believe that he, while in court, he drank some alcohol if these machines are deemed to be valid. And we were about to reprimand him for the 11/7 situation, but now it's time to.
Reprimanding or remanding, he's suggesting that we just do it at a later time to get everything all together.
Okay, well, in the meantime, since these machines.
I'm not gonna take him into custody until I know 100%.
But can we, because he's working, he's come up here, the reason why you put him on Monday, Thursday is because these tamper going down. So we're gonna wait to see if these machines are valid. I'm requesting that we go back to the same bond conditions that we had prior to the tampering. So he does not have to miss work twice a week, coming out here and testing, because all we know, this could be a big mistake.
And I would strongly object to that, Judge, based off what he's on probation for right now.
But the only reason why we're doing the twice testing is because of the tampering. So if the tamperings are invalid, why are we doing something extra when that wasn't what the judge originally wanted?
Well, because there's an allegation right now. We need time to confirm or deny that. But for now, the safety of the community warrants these bond conditions, in my opinion, Judge.
And I strongly disagree.
Mr. Evans, we have a curfew on it, right?
I don't think we have a curfew. We just have the Scram. You just have
He has a
Scram.
curfew, Judge.
What? So, okay.
So,
Are you working now?
yes, sir. I'm working with a hospital in, I have a project with Epic. So I assist physician and nurses on the software they use called Epic. The software is called Epic.
I don't want anyone to lose a job. I mean, the last thing I want is someone to lose a job, right? But I have to know that you're not drinking. I can tell, I know that you tell me no, but all I have are consistent problems. Every time we had you on docket for whatever it may be, there was always problems. Every single time you came in here with the DWI, there were issues. Every time you came in here with the suspended license. And I'm telling you the history that we have, you know? So that's why it's hard to believe all these coincidences when the nature of my relationship with him was every time we had a case, there was at least 3 BVRs, every single.
And I was completely on your side. I thought he was telling me not the truth, but once I saw that he was in court that day.
Let's do this. Let's set it for next week. Let's get every record, subpoena the person, right?
Can we do next Friday, Judge? Is that possible? I'll be in trial next week till about Wednesday. Can we do next Friday? Okay.
Or not Friday, Thursday? Or, okay,
Friday's okay? Yes, Judge.
yeah, and do you want me to waive the appearance?
Can we, I just want you to waive the test.
Oh, okay, I will.
Yeah,
I will.
yeah, that's all I want.
He's got to be here for the next PBR here.
No, yeah, that's fine. Yeah, I just want him to be able to work. So thank you so much.
I'm tired of having to deal with one problem or the other. I would suggest that you go now, go get a new machine so that we know that there are no more issues. Go down there, tell them, hey man, give me a new machine. So that we know if there are any issues, you know, that way you can make sure that you get a new one. Felicia, can we send him for a new one now?
Yes.
Just to make sure that, you know. Okay, so you guys pick it, we'll do it. And then we'll do it. We'll take them off that.
Thank y'all.
Yeah, we'll stop for now. Yeah. Oh, Hugh, sorry for you waiting.
Yes, no problem, Judge.
Tell me, what you got?
I have just appointed to Miguel Mendoza. And I was gonna get his
Oh,
number
Mendoza.
and then give him a call.
Come up, Mr. Mendoza. Positive or coke? Here.
And I went ahead and had him write your phone number so you can give it to.
So Mr. Mendoza tested positive for cocaine.
Okay, is he on bond right now or I guess he's out? Okay, is this his
He's on
first
bond
setting?
for now.
Okay, is this his first setting or?
Look at me. The dope stops now. Do you understand? You test positive for cocaine, marijuana, anything else anymore, I'm going to put you in jail and I'm going to make your bond. Do you understand? If you cannot stop, I will have a contempt hearing, hold you in contempt, slap you with 180 days, probate it for 2 years, and put you in a rehab facility. Do you understand?
Yes, sir.
I am giving you the opportunity to stop using now. If I find that you're using, I don't care what you come up here and try to explain to me. I've got a prescription from England that tells me that I need to use cocaine. I don't give a rat's behind what your excuse is. You use, you will stay with me. Do you understand?
Yes, sir.
Do you know if Mr. Mendoza has a Texas driver license? Mr. Mendoza, this is an affidavit. This is an affidavit that you're going to sign with me today, promising me that you're not going to use marijuana, cocaine, methamphetamine, any illegal drug or unprescribed controlled medication. Do you understand?
Yes, sir.
I've given you a lawyer. It is your responsibility to stay in touch with him. I am now going to test you at least 2 times a week so that I know that you're not using. Cocaine stays in your system about 3 to 4 days. So I'm going to test you at least 2 times a week so that I know that you're not using. And the next time you test, you will stay with me.
Sure.
Do you understand?
Yes, sir.
Okay. I'll have you come up here, swear test that you're not going to use. I'm going to have you get a Victoria sign and reset. We'll get you with Felicia for your bond conditions. And then as soon as you step out of here, we're going to have you talk with Hugh. And then I will see you back here on Monday to take another test.
Thank
All
you,
right?
Your Honor.
Good luck to you, Mr. Mendoza.
Thank you, Judge. So you think next court date will be Monday or?
Monday. Yep. No, Monday.
Could we do a Tuesday? Because I'm going to be out of, I think I'm not going to be in court on Monday.
You don't have to be here.
Okay.
We're just going to have him here to test.
Okay, gotcha.
But after the weekend, I want him here so I know that he's not using.
Okay.
And then
Sounds
if need be, I'll get a hold of you. I got your phone number and then we can always Zoom if there's an emergency.
Okay.
Okay.
All right. That works,
Okay, friend.
Judge. Thank you.
See you soon. All right. I think that's it, guys. Hey, what percentage would you say are DWIs? Of all the cases that we do on, what do you think? Like 50%? No, 40% maybe? Is it that high?
It's fairly high. I would say closer to 50, at least 50% minimal.
You think so? That many?
Because almost every other case, it looks like it's a DWI.
That and the salt, right? And that's probably those two, 7% maybe?
Yeah.
Because only 1% is like a fictitious plate or something.
Yeah,
Paying with interest?
that and maybe an occasional theft.
Hey, Judge, tell Kathy you love her 3,000. It's a commercial she played this morning. I love you 3,000.
The judge knows where that came from.
Do you?
Is that from,
Commercial or something she played this morning?
no, I'm just thinking Iron Man.
There you go. Yeah. Avengers.
Yeah, the Avengers
Or it
thing.
was a preview, I mean, I said
Oh,
commercial.
she did a commercial for real?
No, well, or maybe a preview, I'm saying it wrong.
Can I
This
see it? I
morning.
want to see it.
Well, you gotta watch her live from this morning.
At 4 in?
No, you can go back and watch it.
Yeah, okay, I'm gonna check it out. Court vibes.
Hi, Kathy.
Hey, guys, all right,
you,
we're gonna let you
3000.
guys go. Thanks for hanging out with us and we'll see you
It's
bright and early
amazing.
tomorrow. Be ready, tomorrow's gonna be busy. Yeah, okay, we love you guys. Thanks for hanging out with us. We'll see you tomorrow.
Oh, yeah. Harris County, Texas leads the country in DUI deaths. It's not something they're very proud of, but it's a fact of life in Houston, Texas. Well, that's all we got for today. That was the whole docket. Sans a lot of resettings that I didn't feel, I feel like in it. The resetting. You'll actually see the case tomorrow or Monday. You don't need to see all that stuff. Cut that down for you. Got you a 4-hour docket down to about 2 hours there. Tomorrow's promising to be a big day. I'll see y'all tomorrow night, if y'all do so choose. We'll be getting things spun back up about 8 p.m. Central Time, 9 p.m. Eastern Time. And I'll be here, because I'm your Lone Wolf Oosel, and I curate these little get-togethers. I cut these dockets down to a more consumable length, at least in my mind. I enjoy it. And I thank everybody for coming out. It's always fun. Chat's been great. And the cases have been very interesting tonight. Had more than a couple of repeats. Oh, and don't ever forget to poke the Colin. Always poke the Colin. Ladies and gentlemen who are still here from the Colin raid, thank you for showing up with the Colin raid. You know, I was technically part of the Colin raid too. I should not probably admit that, but I do. I admit it. I was part of the Colin raid. Raiders are welcome. This is our final Colin pause for the evening. And for that pause, I'm going to be saying goodnight, ladies and gentlemen. I am your Lone Wolf Oosel. I've had a blast this evening. It's 4 a.m. in the UK, and that's just crazy. Semper Fi, have a great day. All the rest of you crazy kids, see y'all tomorrow night. And then maybe, just maybe, I'll see y'all Saturday for brunch. Well, I know I'll be here. Will you? It'll be happening about 11 a.m. Central Time, 12 p.m. Eastern Time. We'll be doing a weekend review. Because I'm your Lone Wolf Oosel. I'm your curator for these videos, and that's what I do. Y'all have a good night. Peace out. Oh yeah. Night, Mom. Night, Dreams. Night, Wixom. Night, Semper. Or good day, Semper. Crazy Cat. We'll just start reading names that pop up in the chat. Isn't that what you're supposed to do? Jenny? Oh, we need more music. Thank you and good night, ladies and gentlemen.